Hi, I'm Shaye Larkin and thank you for visiting. For more than 20 years now, I have been a bankruptcy attorney here in San Francisco, and I prepare Chapter 7 and Chapter 13 bankruptcy cases for my clients. Now, you may have heard these terms before, Chapter 7, Chapter 13, and you may be wondering, what does that mean? Well, these are two very different types of bankruptcy case, and the terms Chapter 7 and Chapter 13 refer to the section in the Bankruptcy Code where these two different types of bankruptcy are primarily discussed. There are other chapters of bankruptcy, but we're only going to discuss Chapter 7 and Chapter 13 in this video. And I can talk about either of these two types of bankruptcy for hours, but in order to be concise, we're just going to limit it to the primary differences between the two. Chapter 7 is what we call a liquidation bankruptcy, which means that assets which are not exempt can be liquidated for the benefit of creditors. That doesn't mean if you file Chapter 7, your assets may necessarily be liquidated. The great majority of bankruptcy cases filed are what we call no asset cases. That doesn't mean there are absolutely no assets. It means the assets are protected by applicable exemptions. So there are state exemptions and federal exemptions, and you choose the set based on where you've lived for the 2 years before filing bankruptcy. It's a little technical, I won't get into that here, but it has to do with where you've lived in recent history. In California, we have two sets of exemptions to choose from, and you choose the set that best affords you the most protection for your assets. So if your situation is such that your assets are all covered by the applicable exemptions, then your case is a no asset case and it will sail through the system lickety split, assuming there are no problems that could result in litigation or dismissal. Hopefully not. So like I said, the best case scenario is you get in and out in about 100 days. Well, Chapter 13, you're looking at a much longer period of time. Chapter 13 plans are usually between 3 and 5 years long. There are cases where you can get out of Chapter 13 very quickly. Those are cases where 100% of the debt is being paid off, and maybe a big chunk of money is coming in, perhaps from a real estate sale, and that's going to pay off 100% of the claims. Then you could get out 6 months or less in that situation. But generally, it's a 3 to 5 year payment plan over time. How long you need to be in Chapter 13 depends on what your income is. If your income is above the median for your state, then you need to propose a 5-year plan. If you end up paying off the plan early because perhaps not all of your creditors filed claims, that's how they get paid, is by filing claims. It's possible to get out sooner than 5 years in that situation, but generally you're looking at being in there for the long haul. It's a long-term commitment. If your income is below the state median, then you can choose a 3-year plan, or somewhere between 3 years and 5 years, or even 5 years. And you may be wondering, why would someone want to be making payments into a plan for 5 years if they didn't have to? Well, there are situations where you really need to. Maybe you have a giant tax debt that is not dischargeable in bankruptcy. Some tax debt is dischargeable, but maybe you have one that's not dischargeable, and you're going to be stuck with this, with the IRS penalizing you for a long time. So you can do a Chapter 13 and make payments on it over a longer period of time. It's cheaper to stretch it out over 5 years than pay it in 3 years, so that might be a situation where a longer plan is chosen. People also file Chapter 13 to manage student loans that have gotten out of control. So now you understand that one of the differences between Chapter 7 and Chapter 13 is Chapter 13 is generally a longer bankruptcy that involves making payments into a plan. Sometimes Chapter 7 cases can go on for years if there's litigation or problems. resulting in litigation. Hopefully that's not the situation for you. Other differences between Chapter 7 and Chapter 13, well, because Chapter 13 affords you a long-term payment plan, you can catch up on things like mortgage arrears, behind payments, owed to your car lender. You can't do that in a Chapter 7. If you file a Chapter 7 and you're behind on your mortgage, as soon as you finish your bankruptcy in about 3 months, your house is at risk of foreclosure. Whereas in Chapter 7, you get a long term of repayment on those behind payments up to 5 years, and at the end of the Chapter 13 plan, you are even Steven with the mortgage lender. So it's a great way to protect your home. Chapter 7 doesn't do that for you. Let's talk about some other differences. We talked about length of time, the ability to repay debts over a long period of time for Chapter 13 versus Chapter 7. Other differences is some debts are not dischargeable in a 7 that are dischargeable in a Chapter 13. For example, you get a divorce, and as part of the divorce settlement agreement, you promise to pay back a certain debt. Well, that particular type of debt is not dischargeable in a Chapter 7, so you may be able to discharge your Chase credit card debt in a Chapter 7 as to the creditor, Chase, but not as to your ex-spouse if you made a promise to repay that as part of a divorce settlement agreement. In a Chapter 13, that particular type of debt, so long as it's not considered spousal support, is dischargeable. And there are other types of debts as well, like certain traffic fines, not dischargeable in Chapter 7, dischargeable in Chapter 13. Dischargeable, just to be clear, that means you no longer owe it at the end of the bankruptcy. Now, other differences, there are things that you can do in Chapter 13 that you cannot accomplish in a Chapter 7. For example, you can get rid of underwater second mortgages and home equity loans in a Chapter 13. You can't do that in a Chapter 7. So the way we do that is we have to value the home, and if the value of the home is less than what's owed on the first mortgage, or equal to or less, such that the second mortgage or home equity loan is entirely underwater, then we can strip that in a Chapter 13, and we can't do that in a Chapter 7. We can also do something called car cram downs. If you owe more on your car than what it is worth and you meet certain criteria, you can cram down the car to its fair market value and just pay that through the Chapter 13 plan. So those are a couple of examples of things that we can do in Chapter 13 that make it a great option. There's something called a Chapter 20. That's filing a Chapter 7, getting a discharge, and then filing a Chapter 13 right after. And you may be wondering, why would anyone do that? I mean, isn't one bankruptcy bad enough? Well, there are certain situations where that's actually a great idea. You file a Chapter 7 to get rid of all your debt, and then you do the Chapter 13 just to get rid of the second mortgage lien, or just to pay back the huge tax debt that's not dischargeable in the Chapter 7. So there's great things that we can do with these two different types of bankruptcy. Can everyone file a Chapter 7? No. Actually, let me correct that. Anyone can file Chapter 7, but is everyone eligible for discharge? Not everyone is eligible for discharge. Corporations that file Chapter 7 are not living beings, so they don't get a discharge. But even some human beings may not get a discharge in certain situations. If you're a consumer debtor, which means that your debts are primarily incurred for household purposes, then you have to pass something called the Chapter 7 means test. And if you take this means test and it shows you have a certain amount of surplus income at the end, it can raise the presumption of abuse, and then the United States trustee gets involved and tries to dismiss the case, unless you convert to Chapter 13. So in that situation, or if your bankruptcy budget, your income versus expenses, show significant surplus income, it's probably better to look at Chapter 13 instead, because the case is at risk of being dismissed. There's also criteria for Chapter 13. Not everyone is eligible to file Chapter 13. And one of the criteria is you must have regular income. Regular income can be from many different types of income, though. It can be from a job, it could be from gig work, as long as it's consistent. It could be from help from a family. If you don't have a job, but you have a family that's willing to support you and they're willing to sign a declaration saying, yes, I'm going to be providing this amount of income every month while this person is in Chapter 13. That would satisfy the regular income requirement. There's also debt limitations for filing Chapter 13. Your secured debt cannot be more than $1,257,850 currently. That changes over time. Your unsecured debt cannot be more than $419,275 currently. And those debt limitations apply only to liquidated non-contingent debt. And if your liquidated non-contingent debt exceeds those debt limitations, then Chapter 13 is not for you. You can consider perhaps a Chapter 11 if Chapter 7 is totally out of the realm of options. So those are the primary differences. I hope that I articulated them clearly, and hopefully my videos will get better as time goes on. This is a new experience for me. I think in my next video we'll talk more about exemptions, and then I want to get into other areas of bankruptcy. Thanks for visiting, and I have a lot of information on my website if you care to visit that, www.shayelarkin.com. Have a great day. Bye.